So here we are, Kelly, 5 p.m. on the East Coast as this memo, this essentially new pause goes into effect. And some questions that remain about what exactly is being paused. The White House worked very hard to make very clear today, in their view, at the press briefing, they've had a couple of officials out on some of the cable news shows, that what they call individual assistance is not affected. That said, that doesn't necessarily answer all the questions that people have. Fair?
Yes, there are many questions, and we're getting a sense from various types of organizations that rely on this flow of already passed money that goes through federal grants to state programs and different things like that. They have questions because this is a very new approach, and the Trump administration is making clear.
Imagine a real estate empire worth billions, suddenly under the microscope of a court-appointed monitor. Now imagine a $500 million penalty wiped away in a single day. Today, we break down the stunning New York appeals court ruling and what it actually means for the future. Let's play this clip.
What they don't want to have happen, the Trump administration doesn't want any workaround or attempt to intervene or impede those policy objectives of Donald Trump. And that may have in part influenced moving on this OMB memo, the pause we've been discussing, even before there's an OMB director confirmed by the Senate. Right. So they want to make certain that the government is not working at odds with the new president. And that is a tension point that echoes from the first administration of Donald Trump, and is clearly something that he wants to avoid and to use whatever force and influence he has to prevent this time around.
For anyone who has spent time in Lower Manhattan, the architecture tells a story of power, history, and the sheer scale of American commerce. One of the most prominent landmarks in that skyline is 40 Wall Street, a skyscraper that has stood as a symbol of the Trump organization's real estate reach for decades. From the windows of the New York Attorney General's office, that building is visible every single day. It is not just a piece of property. It became a central character in a legal drama that has captivated the nation and challenged our understanding of how large-scale business operations are monitored by the state. For years, the state of New York argued that this building, along with many others, was part of a systemic effort to mislead banks and insurers. The core of the allegation was that financial statements were inflated to secure better loans and insurance rates. This wasn't just a minor disagreement over property values. It was described by the court as a years-long scheme to dupe the financial world. The numbers involved were staggering. In February 2024, a judge ordered a penalty that, with interest, reached nearly $454 million. That number was not static. It grew by over $87,000 every single day that it remained unpaid. But the story took a massive turn that few saw coming. An appeals court in New York has thrown out that civil fraud penalty entirely. A 5-judge panel rendered a decision that effectively wiped away a debt that had grown to more than $500 million. They didn't do this because they found no evidence of wrongdoing. In fact, the panel narrowly endorsed the finding that fraud had occurred. Instead, they focused on the punishment itself, calling the fine excessive and a violation of the 8th Amendment of the United States Constitution. This ruling is a major development because it changes the stakes of a battle that has been playing out in the headlines for over 2 years. While the Attorney General has vowed to appeal this reversal to the state's highest court, the immediate financial pressure of that $15 million bill has vanished. However, the legal journey is far from over, as other restrictions on the Trump family's business activities remain in place. This is the narrative of how we reached this point. What the independent monitors actually found inside the company's books, and how the legal system is grappling with the concept of market hygiene versus political hygiene. To understand the weight of the appeals court's decision, we have to look back at the original judgment issued by Judge Arthur Engoron. The sources show that in his 92-page decision, Judge Engoron was blunt. He stated that the frauds found in the case leap off the page and shock the conscience. He expressed frustration with the defendants, noting a lack of contrition that he described as bordering on pathological. The judge concluded that asset values had been inflated repeatedly to make more money. For example, the sources mentioned that the interest Trump owed on the penalty was calculated from the start of the investigation in 2019 for some portions, and from 2022 or 2023 for others. The penalty was intended to represent ill-gotten gains, the money saved through lower interest rates and profits from deals that might not have happened if the financial statements had been accurate. By the time the case reached the appeals court, the total bill for all defendants, including Eric and Donald Trump Jr., was approximately $464 million, and it was climbing toward the half-billion mark. Attorney General Letitia James made it clear that if the funds weren't available, she would move to seize assets. She specifically mentioned looking at 40 Wall Street every day as a potential target for judgment enforcement. During the time between the original verdict and the appeal, the Trump Organization was placed under the watch of an independent monitor, retired Judge Barbara Jones. The sources provide an incredibly detailed look at what she found during her 14-month assessment. Her team reviewed more than 3,000 documents, ranging from bank statements to tax filings and loan agreements. What they discovered was a complex web of 521 distinct business entities, all held within a revocable trust. Over the course of the monitorship, over 100 of these entities were dissolved because they no longer had a business purpose or material assets. The monitor's reports highlight several areas where the company's financial reporting was either incomplete or inconsistent. One of the most significant findings involved the Statement of Financial Condition, or SFC. Historically, the company submitted these statements to lenders to comply with loan requirements. However, during the monitorship, they elected not to submit SFCs. Instead, they provided a list of material assets and material liabilities, known as a MAML. The monitor noted that this MAML did not include estimated values of properties or a full balance sheet, which was a departure from previous practices. There were also specific errors identified in the documents submitted to third parties. In one instance involving a 40 Wall Street budget, management fees of over $1 million were erroneously excluded, which caused the projected income to be overstated. In another case, a forecast for the Chicago Tower property showed a difference of over $1.5 million in the calculation of earnings because an interest expense was omitted from the printed report. The monitor also flagged math errors in the financial statements for Trump Turnberry, resulting in an understatement of profit by tens of thousands of pounds. Perhaps more importantly, the monitor identified issues with transparency regarding the movement of cash. The sources reveal that the Trump Organization failed to inform the monitor of cash transfers exceeding $5 million that were sent to Donald Trump individually. These transfers totaled more than $40 million and were only discovered after the monitorship team reviewed bank statements. Additionally, the company did not disclose certain tax filings related to a conservation easement at the Doral property until months after they were submitted. The monitor's observation was that these issues reflected a lack of adequate internal controls. The company did not have a formal compliance department and relied heavily on external auditors for annual statements, while internal interim reports were often issued without that same level of validation. While the company was noted to be cooperative in providing information when asked, the monitor suggested that without significant changes, misstatements and errors might continue to occur. This lack of internal control is a theme that appears in other New York legal battles involving deceptive business practices. For instance, the sources describe a case involving the software company Network Associates. In that matter, the Attorney General proceeded under Executive Law Section 6312 to remedy what were called unlawful and deceptive practices. The company had placed censorship clauses on its software, telling consumers they couldn't publish reviews or disclose test results without prior approval. The state argued that this misinformed consumers about their legal rights and violated public policy. In the Trump case, the Attorney General used similar legal pathways, arguing that the persistent use of fraudulent financial statements violated the same state laws designed to protect the integrity of the marketplace. The initial judgment didn't just impose a fine. It also aimed to restructure the way the company operated. It required the installation of an independent director of compliance at the company's expense and extended the role of the independent monitor for at least 3 years. When the case reached the appeals court on August 21, 2025, The conversation shifted from the facts of the fraud to the constitutionality of the penalty. The five-judge panel was unanimous in tossing the fine, but they were deeply divided on almost everything else. Two of the judges, Diane Renwick and Peter Moulton, wrote that while the injunctive relief, like the monitor and the leadership bans, was well crafted to change the company's business culture, the $500 million disgorgement was simply too much. They argued that the harm occurred, but it wasn't the kind of cataclysmic harm that would justify such a massive award. The sources show that another judge, David Friedman, went even further. He was the lone voice arguing that the entire case should have been dismissed from the start. He questioned whether the Attorney General even had the authority to bring a suit over private business transactions where the banks involved didn't complain of being duped. He characterized the lawsuit as an effort to destroy a real estate business and derail a political career, rather than a genuine attempt at market hygiene. On the other side of the panel, Judges John Higgett and Lynette Rosado argued that the case was still meritorious but needed a new trial. They believed the original judge had failed to properly weed out allegations that were barred by the statute of limitations. However, the other judges pushed back on the idea of a retrial, calling it Sisyphean, to try and recreate such a vast record while the lead defendant is a sitting president. They worried that a new trial would essentially consign the case to oblivion. The reaction to the ruling was immediate. Donald Trump declared total victory, praising the court for its courage in throwing out what he called an unlawful and disgraceful decision. He maintained that his financial statements were perfect and that the entire case was a political witch hunt. This sentiment was echoed in his social media posts, where he attacked both Judge Engoron and Attorney General Letitia James, calling her Trump deranged and accusing her of bringing the case only for political gain. Despite the celebration from the Trump team, the legal reality is more nuanced. The sources indicate that while the money is gone for now, the fraud finding itself was endorsed by the panel. This means that the court still believes the padding of wealth on financial statements happened. Furthermore, the non-monetary punishments are still in effect. Eric Trump and Donald Trump Jr. are still barred from serving as officers or directors of a New York company for 2 years. Donald Trump himself faces a 3-year ban on holding a corporate leadership position and a 3-year ban on getting loans from New York banks. These measures effectively remove the family from the day-to-day management of their New York business operations. One practical consequence of the ruling is that Trump is now eligible to get back the $175 million bond he posted earlier in the year. That bond was a placeholder meant to guarantee payment if he lost the appeal. Since the penalty was cut to zero, the bond is no longer required, barring a future reversal by a higher court. The Attorney General's office has already stated its intention to take the case to the New York Court of Appeals, which is the state's highest court. They argue that the decision of the mid-level court should not be the final word, and that the integrity of the law requires a full accounting for the violations found at trial. However, legal experts noted that because the appeals panel was unanimous on the issue of the fine being excessive, it might be difficult to convince the highest court to reinstate it. The sources suggest that this case is part of a much larger legal landscape. While this specific penalty was overturned, other civil judgments remain, such as the $83.3 million verdict in the E. Jean Carroll defamation case. Additionally, the Trump administration has begun to use its own federal power to push back against the New York Attorney General. Recently, the Justice Department issued a subpoena against Letitia James, seeking records related to her investigations. Her representatives have called these probes improper political retribution without a credible foundation. As this legal battle moves into its next phase, the core question remains one of accountability and the limits of state power. The sources show a clash between a state's effort to enforce business regulations and a defendant's claim that those efforts are being used as a political weapon. It is a story told through thousands of documents, complex financial structures, and the high-stakes world of New York real estate. The independent monitor's findings of math errors, unreported millions in cash transfers, and inconsistent reporting standards highlight the challenges of overseeing a massive private empire. At the same time, The appeals court's decision serves as a reminder of the constitutional protections against excessive fines, even in cases where a court finds that the law was violated. For now, the skyscraper at 40 Wall Street remains under the Trump name, and the $500 million threat has been lifted. But with the Attorney General heading to the state's highest court and the monitorship continuing for years to come, the final chapter of this narrative has yet to be written. The legal system continues to weigh the venial sins of inflated assets against the mortal sins of the market, searching for a balance that satisfies both the law and the Constitution. Dealing with the financial oversight of a global business is a bit like maintaining a massive, complex bridge. The independent monitor is the structural engineer who finds the rusted bolts and the missing blueprints, ensuring the whole thing doesn't collapse under the weight of its own complexity. Meanwhile, the appeals court acts like a safety inspector, making sure the penalties for those maintenance failures don't exceed the damage they actually caused. Both are trying to keep the path of commerce safe, but they often disagree on just how much force it takes to get the job done.